I think we're going to begin with some housekeeping. First, thank you so much for joining us on our monthly public webinar on different legal information. This one is very relevant because it's terrible outside. Tenant remedies for broken air conditioning. I'm so grateful that we have Community Legal Services Managing Attorney in our Yavapai office, Martin Coleman, who will be giving this presentation today. You are free to ask questions. Just put them in the Q&A. This is being recorded so that we can put it on our YouTube channel. So we will answer questions at the end. Please know that Martin will just be able to provide legal information. He cannot give you advice about your individual situation during this webinar because of attorney-client privilege, but we will give you information about how to apply for assistance at Community Legal Services so that if you do need individual legal advice, you can apply. But today we're going to focus on legal information, and again, Martin can answer questions. Just put them in the Q&A and we will get them at the end. Again, we do these every single month, so please look on our social media for our next topics. They are on all the different various issues that Community Legal Services can represent and assist individuals. With that, I am now going to hand it over to Martin to take us away.
Thank you, everybody. I am Martin Coleman, up here in relatively cool Yavapai County. This is a webinar regarding tenant remedies for broken air conditioning, otherwise known as Arizona Law Cares About Air Conditioning. I sympathize. Even though I'm up here, about a week and a half ago, I helped my daughter move from Tempe to Central Phoenix in the middle of the day for the whole day. Oh my, you know what? Wow. So, and my truck's air conditioner broke down. So I sympathize. Now, let's get to the law. Next screen. Who are we? Community Legal Services is a not-for-profit law firm that strives to assure fairness in the justice system, no matter how much money you have. Our income limits are based on federal poverty guidelines. I don't want to give you a specific limit because I want you to call us. And if you think you're eligible, call us. We'll tell you if you're eligible. CLS was incorporated in 1952 in Maricopa County. Our organization at that time was designed to promote something we say every day in our Pledge of Allegiance. Well, we used to say it in school: equal access to justice for all. Community Legal Services' mission is to increase fairness in the civil justice system by advocating, litigating, and educating, as we are today, on behalf of Arizona's most underserved communities. Community Legal Services' vision is to be Arizona's leading legal voice for communities in need to protect their rights, increase fairness, and provide access to justice for our underserved communities. Next slide. CLS has offices in the western half of the state, all the way up from south to north. We start in Maricopa with over 5, almost 6 million people. Yavapai, a lot less. Yuma, La Paz, and Mojave. We have 3 offices. Prescott, well, 4. Prescott, Kingman, Yuma, Phoenix, and also an office in San Luis right on the border. Our numbers are here and our addresses. You can get a hold of us by looking up online Community Legal Services and Free Civil Legal Services. It'll lead you to our websites. Next slide.
I'm just going to jump in real quick to tell you about our tenant eviction assistance project. As Martin said, normally we represent people who are low income, and we have in all of our offices that Martin went over advocates who can represent tenants who are having habitability issues or eviction issues, among many different types of civil practice. However, we have a special grant with the City of Phoenix and Maricopa County. For those tenants that are facing an eviction, they can call this number that's on here, 602-385-8880, or our main numbers that we'll go over at the end. And we can assist you, provide advice to direct representation, regardless of your income. So this is a special grant that no matter your income, we can assist tenants in Phoenix and Maricopa County if you're at risk of an eviction.
Next slide. Now, about this presentation. This presentation covers residential rentals that fall under a law known to the public as the Arizona Residential Landlord and Tenant Act, and we call it the capital A, capital R, capital L, capital T, capital A for short. The ARLTA covers all traditional types of rentals, like in a multifamily housing complex, or a home, or apartments in a home. It also covers people who reside in mobile homes, manufactured homes, or RVs, where they rent both the home or RV and the land and the space on which the home sits. The ARLTA does not cover mobile home or manufactured homes or RVs when the person owns the vehicle or mobile home, but only rents the ground space. A copy of the ARLTA can be found on the website of the Arizona Department of Housing. Now up here is a screen. I will not try to repeat that. You will not remember it. If you can copy it, great. And we do have this presentation available on our YouTube website for our webinars, like a library, available. So go to CLS, Community Legal Services website, for those documents. The Arizona Department of Housing website is pretty easy to navigate. I'm on it a lot. And so you should be able to find that easy once you get on the website. Now, please note once again, this presentation I'm giving you is general information regarding Arizona's ARLTA and other laws. It is not a substitute for legal advice that is relevant to your specific factual case or issue, or the people you help in your everyday lives who need help that we're giving today. They should consult with an attorney, or you should consult with an attorney specific to you, to help get assistance specific to your need. And think first, if you can't afford an attorney, CLS. And by the way, we have sister organizations called DNA Legal Services in the north part, serving Coconino and Indian Country, and then SALA, S-A-L-A, serving the southern tier up through Pinal and Pima and so on. Next slide. Here are these laws are the heart of the protections that Arizona law provides regarding air conditioning. These are landlord requirements in the Arizona Residential Landlord Tenant Act in a section known as Section 33-1324. That requires that all owners and landlords maintain in good and safe working order and condition all heating, ventilation, and air conditioning. It also requires that they supply, quote, reasonable heat and reasonable air conditioning or cooling when installed and offered. There are some limited exceptions to this. And then some Arizona cities have local laws related specifically to air conditioning and cooling, which I will go over. The one thing I want to say when doing this, I think all of you should read the law. In fact, when I give advice to people, I say, it's easy to find, it's free, it's online. Rather than relying on what an attorney is telling you, be skeptical, read it yourself. It is online. So once again, 33-1324 is where this law is. Next slide. Now, I mentioned other cities having laws in addition to the Arizona state law in the ARLTA. Phoenix and Glendale have laws where every rental unit where such systems are installed have cooling capable of safely cooling all habitable rooms, bathrooms, and flush toilet rooms to a degree no later than 86 degrees if cooled by evaporative cooling, or 82 degrees if cooled by air conditioning. How do you measure that? The temperature measurements would be taken at a distance of 3 feet above the floor in the center of whatever room that you want air in. Now, required cooling shall be provided by permanently installed cooling facilities, and this is what that really means. You've had or used or seen window air conditioning units that serve a particular room or adjoining rooms. That's one example. You've all had or heard of central air conditioning, throughout an entire house or in a multifamily complex. Those are permanently installed cooling facilities. I want one bit here about the part up top where it says where such systems are installed. Many laws presume that if you don't provide air conditioning with the original lease, like they're renting you a home with no air, not common in the southern part of the state or in any part of the state, well, then there's no requirement that you actually do it unless a local law says you have to do it in a rental circumstance. Next slide. Now, Tempe is a bit different. It's essentially the same thing as Phoenix and Mesa, or Glendale, excuse me, but there's a difference in the cooling. So for evaporative cooling, it's 88 degrees minimum, before it has to be, can't be any hotter than that, or for evaporative cooling, 82, the same as Glendale and Phoenix. Now so everything else is exactly the same. How you measure it, that the required cooling shall be provided by permanently installed facilities. There's an exception in Tempe. Those air conditioning facilities that serve more than one rental unit shall only be required to be designed and operated in conformance with manufacturer's specifications, meaning somebody makes a central air conditioning unit that is meant to provide cooling throughout an entire building that might have 4 or 8 units in it. And with regard to that, these units often come with pre-programmed computer chips that sensor the air outside and in and then set it. Well, in that case, they're not going to get complicated because the directions to the air are preset by these computer chips installed with the manufacturer's product. Next slide. Lack of cooling materially affects health and safety. We don't need to tell you this. We read it every year. I believe I read in the last couple of weeks that in the Phoenix area, approximately 300 people passed away last summer, the last seasons, more than summer, because of it being too hot, heat strokes. And now I told you that Arizona's laws care about air conditioning. Well, there's another one, and this one is known as Arizona Revised Statutes, and it's section 9-1303. This statute is incorporated into the ARLTA and specifically section 33-1324. But sometimes if you read laws enough, you're going to see one law citing to another law. That's what we call incorporating that law into the other law. And here, when 33-1324 describes material health and safety and cooling, it cites to this law for the things that it covers, because that law says material health and safety. It doesn't say specifically air conditioning. So in ARS 9-1303, it specifically says that one of the things that must be covered are, I'm going over to the bottom, lack of adequate heating and cooling. So it also, of course, provides sanitation, ventilation, or space requirements. And ventilation is, well, let's call it a passive way of allowing airflow to flow through a house and, moderate the outdoor temperature. This law is incorporated into the other law in the ARLTA, and they work together to specifically address the requirement to cool. Next slide. Notices. Well, if you want to engage the force and the power of a law, we call that enforcement, then you have to serve a notice. And in Arizona, notices are designed to give an owner, when it comes to the tenant's rights here, give an owner notice before a person seeks a remedy under the Arizona Residential Landlord-Tenant Act. So now, a little bit more about notices. Under Arizona law, a notice generally should be in writing. Often the laws will say specifically must be in writing. When you read a law, look for the word notice and writing. That's what it says. It's got to be in writing. And writing can be a text. Text is writing. These days, everybody texts. Email or writing. So there's no magic to the form. The only requirement is that it be reasonably calculated to be received by the owner. And so if you ordinarily communicate by text or email with the owner, you can do it. Even if you text by mail or through some portal, if you get a hold of another number and you can text or email them, do that too, but use the means designated in any lease to communicate it as well, because you want to make sure you comply with the lease when you give notices. Next slide. Five-day notice. This is for health and safety. This is specific to the circumstance we're talking about, where you want to engage one part of the law and one remedy under the law. So health and safety is well, when you don't have air in a lot of parts of Arizona, your health and safety is impaired and at risk. Think I mentioned about 300 people passing away last year. Think of how many thousands had heat stroke and how many of them went to the hospital. So non-compliance by the landlord in a manner that materially affects health and safety, you can serve the landlord with a written notice, and the law requires a written notice under this section, which will, 1, specify the acts and omissions constituting the breach. Good legal words, meaning simply tell the owner with enough detail what the owner is not doing that the lease and the law require the owner to do. And 2, stating that rental agreement or the rental agreement will terminate. Now, let me step back. This is more complicated than it seems. I'm going to read this as it is and then explain a little bit why it's complicated. Stating that the rental agreement will terminate upon a date not less than 5 days after receipt of the written notice, specifying the breach to the landlord, and the landlord then doesn't remedy the problem within 5 days from receipt. Now, you might be saying to yourself, well, that sounds good, except I got nowhere to go. So what good is it going to do me? Well, the law is more than what I just read to you. The law says, in addition, that you don't have to say that the agreement will terminate in 5 days unless it's fixed, unless you want it to terminate. Maybe you have a place to go and you want out. You just leave out the words will terminate and you say in the notice, state that the rental agreement requires that the owner remedy the problem within 5 days after receipt of this notice. And if the landlord does not, the tenant will seek lawful remedies under the law. So you take away the termination part and just say receive or request lawful remedies under the law. And those lawful remedies can be what we call damages or monetary damages. And also something called injunctive relief, which means an order of a judge telling an owner to do something or stop doing something that doesn't comply with the rental agreement or the law that I read to you, and I'm going to go specifically to 33-1324, the other one that incorporated it, 9-1303, and then this one below is called a remedy law. Remedy meaning how to fix the problem. So 1324 describes what the problem is. 1361 says, here's how you fix it. Next slide. Now, there are other options, and they're a little complicated. Self-help option. One option under what's known as Arizona Revised Statutes, Arizona Landlord-Tenant Act, Section 33-1363, there it is at the bottom, says that if the cost to fix is less than $300 or is less than an amount equal to 1/2 of the monthly rent. Let's say your rent is $1,000, so half of that is $500, whichever amount is greater, 300 or in this case, the 500. And now notify the landlord of your intent to fix the problem at the landlord's expense and with 10 days notice, unless if it's an emergency. For example, if it's a heating issue and you truly could pass out in, any time now, just tell them it's an emergency. It needs to be fixed immediately. Immediately makes the point here. Then there's also the 5-day notices for health and safety. I would suggest you say, if it's air conditioning and you're worried about somebody's health, it's an emergency and in no event less than 5 days. That way you cover both. Now here's the problem with the law. Licensed contractor is supposed to be involved in this, and a waiver of a lien, oh my gosh, I'm never going to do that. I forget about it. What's the point of the law? Well, there is a practical solution that will work most times, especially when it comes to things like air conditioning. Picture, the air conditioning stops working, and you have 1 or 2 rooms, maybe a living room and a bedroom that you really need, and the living room is attached to the kitchen and open. Well, if you buy a $400 air conditioner that goes in a window from Lowe's, and you put one in each room, or just let's say you put one in, well, you just spent $400, which is less than the $500 on your $1,000 rent. It's half, and voila! Now, do you need a licensed contractor to go buy an air conditioner and install it in the window from Lowe's? No. What do you do with the notice? This is where your notice comes in. You just say in the notice, in addition to landlord, the air conditioning's broke. I need you to fix it immediately. And then the landlord doesn't fix it or doesn't say, I can't get there till 2 weeks, or doesn't give you any definite date. You say, okay, let's say it's 5 days. You waited 5 days. I'm sorry, torture. I know you wait 5 days just to be cautious. Still not fixed. So you send the landlord a notice saying, I waited 5 days. You didn't fix it. I'm going to go buy a $400 air conditioner from Lowe's and put it in the window myself. And I don't need a licensed contractor for this, and I don't need a waiver of a lien. So I'm just going to deduct it from the rent at the next month. Now you say one more thing, because this law technically requires a licensed contractor. And you know how those judges get. They're crazy sometimes. They make you stick to the letter of the law. So what do you say? You say, if you object to this means of solving the problem, please advise me immediately. Please advise me right away, something like that. So you tell the landlord, look, you want to give me a hard time, you got to tell me in writing. Most landlords will not object to this, but you never know. There are landlords who are merciless and just don't care. So you do everything you can with a notice. This is an example of the law definitely not being perfect. Next slide. Reasonable substitutes. There's another law. It's Arizona Revised Statutes, Section 33-1364. And when I say Arizona Revised Statutes, that's the same thing as the A33 is ARLTA, which is, that all those sections in 33 from 1301 to 1381. Now, if a landlord deliberately or negligently fails to supply air conditioning or cooling, when it's installed with a lease, beginning, the tenant may give reasonable notice to the landlord specifying the breach, meaning that you're not complying with the rental agreement, which came with an air conditioner, and also the law that supports it that I've been reading you. And the tenant may do one of the following. This should be a notice in writing again. And it doesn't require necessarily a notice, but even if the law doesn't require a notice explicitly, send it anyway. Now, under this law, when you're faced with this situation where you have an immediate threat to your health and safety from no air conditioning, let's say you're, 80 years old and you're a couple and, this is a serious medical matter for you. Well, you're entitled to procure a reasonable substitute. And procuring a reasonable substitute means, for example, could be hot water, running water, heat, and essential services. And I'll explain to you now. Essential services, it is generally understood that essential services in the southern part of the state and probably in pockets in north, like Kingman area and the Cottonwood area and then the Verde there, get extremely hot, and it's essential to have air. Now, during the period where the landlord fails to provide it, the tenant can deduct actual costs of getting reasonable alternative substitutes. But tell a landlord. If nobody tells the landlord, how do you expect the landlord to know? Then why would a judge want to hold the landlord responsible? So, written notice, the best way to prove anything, always send written notice immediately through every means possible. Now, a note. This law does not specifically include air conditioning or cooling, just essential services, as I said. But it's, again, generally understood that means air conditioning or cooling. You can look to 1324 and 9-1303 for proof of that. Now, procuring reasonable substitute housing, there's another way you might do it other than buying an air conditioner. You might, what if the landlord said, okay, I'll have somebody there in 3 days. Can you last 3 days? Well, under this law, if you gave the landlord the notice, then you could go to a hotel where it's cool and pay there for 2 days and deduct the rent. Now, as Pam reminded me earlier, hotel does not mean the Phoenix Resort. It might mean a Motel 6 or something like that, a reasonably priced hotel. Okay. Now, there's another theory of recovering damages, and when we say damages, we mean monetary damages, based on what we call the diminution of the fair rental value. I am so sorry about that. Sorry about that. Okay, there we go. Procure recover damages based on diminution of the fair rental value. Lawyer's words again. What does it mean? When you lease a place, you look at it. It has a stove. It works. It has air conditioning. It works. It doesn't have mold all over the walls. It smells reasonably good. It looks reasonably good. Now, what happens when there's a hole in the roof you didn't know about? Now the mold comes into the bathroom first and then the rest of the walls, and then the air conditioning breaks down and the stove doesn't work. Well, you bargained for a place with a stove, with air conditioning and no mold. And when those things happen and the owner doesn't respond to your written requests to make the repairs, then the law says that this diminished, or basically you didn't get the benefit of the bargain. So now the law says, hey, you can sue the landlord and recover money because what you went through for the last 3 months or 6 months was live in a place that wasn't worth the amount of money in the rent that you paid for. The rent represented a good place, not a bad place. So then you just say, okay, I think it was worth half the rent I paid, and so I want the landlord to pay me back. Let's say you paid $2,000 a month in rent. Well, for the last 6 months, you owe me 500 times 6, $3,000. Please, Mr. Landlord, send it back right away. And that's the idea behind this cause of action. Next slide. Retaliatory conduct. You could guess any law that allow the landlord to retaliate when you complain about health and safety matters isn't fair. And Arizona's is generally fair. It doesn't allow the landlord to retaliate if you make a complaint to the landlord about a matter affecting the health and safety of your rental, or you make a complaint to a government that's like a code enforcement agency, and then they contact the owner, and the owner does one of the three following things within 6 months of you complaining: increase the rent, decrease services, and most commonly bring an eviction action where they want you to get out and they tell the judge you're doing something wrong, like you violated the lease by not cleaning not doing the landscaping, or you made too much noise, or you yelled at the landlord or something like that. So you plenty of, or the landlord might just say, if it's a month-to-month tenancy, I'm sending you a 30-day notice to not renew, and not even specify why they're doing it. Well, if they do these things, and within the last 6 months you made a complaint about health and safety, or a government enforcement agency did, then you can try to defend an eviction action, if one is brought against you, saying that the real reason for the eviction was retaliation. I have a little caveat on that. Caveat meaning hold on a minute. It may not work so well for you. If you're in court defending an eviction action, and your only hope is to prove retaliation, if you don't win, you're out and you got a record that will haunt you when you try to rent other places, including low-income housing. You don't want that. So you got to assess risk. Do I want to risk the event that I won't win on retaliation, get evicted, and then have this problem haunt me down the line? So you want to be darn sure you're going to win, and if you're not, it might be wiser just to vacate and avoid a suit. Now, this retaliation law also allows for monetary damages and can be brought separate from an eviction action. So, for example, like a diminution of rental value case where you can just sue the owner saying, hey, not for nothing, but you owe me $3,000 for not giving me the benefit of the bargain. Well, you can say, the landlord tried to retaliate against me. You may be out already because you vacated. Well, then you file suit in justice court or small claims court saying, and the landlord retaliated against me. Here's my proof. All I want is the damages, the money. And so that's a different circumstance. So the law does allow just to bring that if you decide perhaps I want to vacate and not risk an eviction action on my record. Next slide. Now, consulting with an attorney. I'm going to give you a warning I gave you already, and be more specific. I don't want to make it sound like these laws are so easy to use that you can use them without consulting with an attorney. It gets complicated. You all know that. Life gets complicated, and we're here. So are some other lawyers, other not-for-profits like ours in different parts of the state. You should ask us for help. I applaud you for doing a lot of it yourself, but if there's time, then try to get in contact with an attorney, try to get the advice, and make sure you're on the right track, and you consider all the issues like, do I want to risk an eviction with a retaliation defense, or, how and when do I want to bring a diminution of rental value claim, and what do I have to say in a notice to try to get a lender to fix things and get my air going as soon as possible. Next slide. Now, form notices. Well, Community Legal Services does a lot of things. We defend, like we say. We advocate in many ways, advice and legal assistance. We also educate. And in furtherance of our mission to educate everybody out there, we've put together form notices that are on our website and located in different places online that you can use to send to owners. You don't have to try to struggle with the words yourself. You can just fill in the blanks on our notices. They are in what is known as the CLS, or Community Legal Services Tenants Handbook. This website, the URL here, that'll get you there. Nobody remembers these things. So type in Community Legal Services. It will lead to our website, and then use the search function to search for CLS, or Community Legal Services Tenants Handbook, and use the forms. They're free, they're yours, have at them, and call us for assistance while you're at it. But if you need to do something immediately and you can't get a hold of us for a few days, use the form and the instructions, and hopefully that will help you, and we can follow up and make sure that things go as well as they can for you. Next slide. How to reach us.
Yes.
I think it was Pam, right?
Yep, I can do it real fast. Before we get to questions again, while I'm doing how to reach us, you can type a question in Q&A and we will try it. We will have Martin answer it. So I mentioned our Maricopa County grant that allows us to represent individuals who have higher incomes than normal. If you are in Maricopa County and you have you're at risk of eviction, you can reach out directly to our Tenant Assistance Eviction Project, our TEAP program. That's that first number. But for all other landlord tenant issues or other civil areas that we practice that you can look on our website, you can call our number or go to AZ Law Help and apply for services. Also, in Maricopa County, you can reach us in person on Wednesdays and Fridays. On Wednesdays we're at Native Health, and on Fridays we're at Mesa Can. Also, Martin showed you each of our rural offices. You can go onto our website to find out how to apply, and if the rural offices, if you can apply in person by looking on our website. But you can find all of this information, how to apply, on our website also. Okay, Martin, we are going to look to see if we have questions now. Again, you can put those in your Q&A. Our first question is, Martin, does Mojave County and/or Bullhead City, Kingman, Lake Havasu have specific laws regarding the AC for renters? That's our first question. Or I think similarly, like, how do people look up to see, where should people look to find out if their town has a specific rule?
That's a really good question, and I'm glad you asked it. We spent a lot of time trying to find these local laws in Arizona, like the ones for Prescott, for example, or Kingman or Mojave. They are hard to find, and we're lawyers, so I can imagine how difficult it might be for you to find them. Well, we are continuing our efforts to locate them. It is our intent to list everything we're able to locate on our website as one of the documents we provide on the Community Legal Services website. Now, we don't have that document yet. I believe we have it started. What I do when I want to find a place is I type in online the local city. So, for example, Kingman, and I type in code, which is how they define their laws, C-O-D-E. And then I type in a subject matter words that would be designed to bring me to those, all laws that have the words air conditioning in it or evaporative cooling. Now, having looked at these laws, they commonly use those two groups of words, air conditioning and evaporative cooling. They sometimes also have heating, but since we're talking today about this, let's just limit it to a search for the following terms: Kingman, code, air conditioning, and evaporative cooling. That's how I would look.
That's right. Looking on the code enforcement of the city, that is to find out whether they have a rule or not. I love this next question. What if the tenant renter is constantly behind in rent? Does the landlord still need to provide working air conditioning, or did the tenant renter breach the lease first?
That's a great question. Well, here's the answer in detail. Every time the tenant's behind in rent, the tenant breaches the lease. But when you mention in a question that the tenant's constantly behind rent, that also tells you the tenant constantly catches up. So what we always look at, what is the situation when you have the particular problem you need help with? Hopefully, they've caught up. Now, if they haven't, let's just assume someone's behind 1 month's rent. The owner still has an obligation to do it. So, for example, the tenant's breach of the lease doesn't excuse the owner's obligation to comply with its obligations under the lease, and vice versa. The landlord's breach of the lease, meaning I'm not fixing your air and I'm required to under the law on the lease, doesn't excuse your obligation to pay rent. So my advice, don't give the landlord a freebie because the landlord's been, screwing you for a while by not doing what the landlord, no, I shouldn't say that. I hope to use that word too much. Landlords are notorious in our job anyway for not doing this. We get these cases all the time. It's natural for someone to think, oh, why should I be paying you money or as much money as the lease says when you're not giving me what the benefit of my bargain was? That is logical. But the law is not logical, the law is rigid. And the law says if you don't pay your rent, you can be sued for non-payment of rent. You can be out in 5 days once they, soon after 5 days after they give you a notice to pay. And if you can't, they can file in court and you can be in court in a week. Don't risk it. Pay the rent. Use the advice we have here. Use our forms. Call us. And later on, if there's money to be settled, do it in a way in which you have point of advantage, not a point of disadvantage. Not paying the rent starts you at a point of disadvantage. Thank you.
So you're saying, Martin, they're going to pay the rent and then maybe they can bring a lawsuit against the landlord separately later if there are other issues, but to never not pay the rent, right?
Yeah, exactly. I said that in 4 times as many words.
It's late in the afternoon, so I just needed to be clear too. Okay, that is all the questions that we have. It looks like you can always reach out to info and ask us general questions to CLS. We really appreciate Martin. Wait, I think we have one more that we will try to answer if we can. Great. It says that they're a new investigator. They're looking, they will have them call CLS in our Kingman office. And that, yes, we have an amazing office in Kingman, great staff. So please feel free to call our offices directly, or you can call that main number I gave to reach any of us, any of our offices. Again, I want to thank Martin so much for this great information and all of his years of wisdom and his practical knowledge too. Very, very helpful, Martin. So thank you. And thank you for everyone joining us today. Please look on our social media coming up to see what our next topic will be. Again, we will be doing these every single month. So thank you.
Thank you all.